morning or good evening, everyone, and welcome to this IISD webinar on compensation under investment treaties, exploring options and for reforms. I'm Susie Nikiema from IISD, and I'm really glad to moderate this session today. Before I introduce you to the agenda and speakers, let me first provide some housekeeping information. French translation is available today. So for our francophone colleagues, la traduction française est disponible et vous pouvez y accéder en cliquant sur le symbole du globe en bas de votre écran. As speakers are presenting, please feel free to ask questions and share comments on the chat or Q&A function. You only have 1 hour and 13 minutes for this discussion, and then we will prioritize questions in writing to give a chance to a maximum of participants to interact. But we will try also to take some few oral interventions if time allows for. Kindly note also that this session will be recorded and we will circulate a link to the recordings afterwards. So feel free to share it with your interested colleagues that were not able to join us today. So what will we discuss today? I will first invite Nathalie Bernasconi-Osterwalder, Executive Director of ISD Europe and Senior Director of Economic Law and Policy Program of ISD, to make her introductory remarks. Then Jonathan Bonitsa, who is Professor at Law Faculty of University of New South Wales and Senior Associate at ISD. And Sarah Brewin, who is International Law Advisor at ISD, will introduce us to the main problems with compensation under investment treaties and explore some possible options to address them. Jonathan and Sarah are the two co-authors of ISD recent publication from which this webinar is drawn from. And the paper is available on our website, and I will ask my colleague Jo Zhang to post the link on the chat now so you can access to it. And a French translation will be available soon. After this presentation by Sarah and Jonathan, we will open a Q&A session. Without any further delay, over to you, Nathalie, for your introductory remarks.
Thank you very much, Susie. And now on behalf of IISD, I would like to welcome all of you to this webinar on compensation under investment treaties, exploring ideas for reform. The critical issue of compensation or damages in international investment law is gaining increased attention due to concerns about the high and growing scale of investor-state awards. Today, there are 50 known cases in which a tribunal has awarded compensation over $100 million. Even more astonishingly, we already have 8 known investor-state arbitration awards of over $1 billion today. And this does not even include awards in contract-based investor-state arbitrations, which are often not public and have also led to multi-billion-dollar awards. In this very trying moment of crisis of the COVID pandemic, when countries are debating about the budgets they have available or not to support their people and companies in crisis, these very high award amounts are particularly worrisome. For many states now facing these high awards, the issue of compensation principles and valuation techniques were never really discussed or thought through at the time they concluded the agreements. The skyrocketing awards handed down by arbitrators over the past decade has come as quite a surprise to many governments. Concerns about these unexpected and unintended developments around compensation in investor-state arbitration have been voiced at UNCITRAL, and the issue is now included in the agenda of the UNCITRAL Working Group III on investor-state dispute settlement reform. UNCTAD's new IIA reform accelerator process, which has just recently been launched, will also be an important platform for further discussion on the topic of compensation. In today's webinar, we will focus on what real reform of compensation under international investment law could look like. How could the principles of compensation and valuation techniques applied by arbitral tribunals today be fundamentally reoriented to address concerns with outsized awards? This webinar aims at starting a discussion around exactly these questions. The ideas that we will cover in the webinar are drawn from a longer paper that has just been published and is available on our website in English, with French soon to come. We want to thank the practitioners and academics who have provided valuable input into this paper, and we're very pleased to see that some are joining this webinar today. So let us begin our discussion. Dr. Susie Nikiema from IISD, as we heard, will be moderating today, and she has already presented the co-authors of the paper. After their presentations, we will have 30 minutes open discussion moderated by Susie with the support of her colleague Joe Zhang. And then Susie will wrap up so that we can have that we can close the session at 1:15 the hour, I think. Or Susie, you'll have to correct me if this was wrong, because I think I heard you say something different. We'll in any event end on time. And before we end, let's have the discussion. And I now have the pleasure of giving the floor to Sarah Bruin, who will begin with her presentation. Thank you very much.
Thank you very much, Natalie, for those opening remarks. Thank you to Susie and to all of you for making your time available to join us today. So I'm going to kick off the presentation by taking us through 7 key policy concerns that we've identified in the paper that relate to the way compensation is currently awarded under international investment treaties, before I turn over to Jonathan, who's going to present 4 potential reforms that could address these problems. So if I could just have my next slide, please. The first and perhaps the most obvious of these problems, and the one that Natalie alluded to in her opening, is the fact that the amounts of compensation being awarded are large and they are increasing. So in the early 2000s, awards in the tens of millions of US dollars were considered to be large. And these sums now seem quite quaint in retrospect. These earlier awards have now really been dwarfed by what are increasingly being described as mega awards. So as Natalie mentioned, today the largest known award is the 40 billion US dollars against Russia from 2014. And we now have 50 known cases in which a tribunal has awarded over $100 million, with 8 awards over $1 billion US dollars. And I would argue that these are really large figures, both in relative and in absolute terms. So firstly, they're large relative to the size of awards 20 years ago. And you can see in the graph on the screen at the moment, which charts the rolling 10-year average award size. This shows us that in the last 10 years, awards have been climbing in size. And then I would also say that awards are large relative to states' budgets for public spending, which again, as mentioned by Natalie, is a particularly critical issue at the moment. So for one example, in the Union Fenosa gas case, Egypt was ordered to pay $2 billion US dollars plus interest, which was equivalent to 12% of Egypt's national budget for health and education in 2018-19. Finally, I think most of us would agree that some of these awards, such as the $4 billion US dollars plus interest against Pakistan in Tethyan Copper, are simply large in absolute terms. So my next slide, please. The second key policy problem that we've identified is the fact that these large awards of compensation are increasingly being made in regulatory disputes, even where the investment continues to operate profitably. So to understand this problem, it's important to consider the the roots of existing treaty provisions on compensation, which were developed during the decolonization era of the 60s and 70s. At that time, there were really stark disagreements between developed and developing countries over how much compensation should be paid for expropriation of foreign-owned assets. Despite this disagreement, both developed and developing countries agreed on one key assumption, and that was that investment disputes usually involve an outright seizure of a foreign-owned asset by a host state. And so it was with this type of dispute in mind that developed countries thought that compensation should equal the fair market value of an expropriated investment. And while developing countries argued for a lower standard of compensation, it was developed countries that effectively settled this controversy by embedding the fair market value standard in the language of investment treaties, at least where compensation for expropriation was concerned. So while the development of compensation principles happened at a time when notions of treaty breaches were really rooted in the idea of an asset seizure, most modern investor-state disputes arise from regulatory interactions between the state and the investor, where the investment is not seized, but rather it continues to be operated. So one example of this type of case is a series of arbitrations against Spain in response to the government's changes to the tariffs paid to generators of solar electricity. The outcomes of this series of cases are inconsistent and range from large awards of compensation to the outright dismissal of investors' claims in their entirety. So for example, in Nextira in Spain, the tribunal awarded the investor $323 million in compensation on the basis that the investor was entitled to the above market rate of return that it would have obtained in the absence of the regulatory change. So because the principles of compensation found in investment treaties weren't designed with these types of regulatory disputes in mind, applying them in the context of an investment that is not seized and that in fact continues to operate results in these kinds of anomalies and inconsistencies. So on to the next problem. Another stark anomaly which shows that the current compensation principles are really not fit for purpose is the fact that we've seen large amounts of compensation awarded for interference with planned investments that were never actually built. Tribunals have been increasingly willing to grant large amounts of compensation for state interference with these planned investments. In these cases, the difference between the amount actually invested by the investor and the amount that they obtain in compensation can be really vast. So in Tetian Copper in Pakistan, the foreign investor was awarded $4 billion plus interest for Pakistan's failure to grant the necessary approvals for an investor to build and operate a mine, even though that mine was never built. The tribunal calculated compensation on its estimation of the income that the investment would have earned over its entire 50-year operating cycle had it been built. Just for scale, this award is almost as large as the IMF bailout that had been agreed just 2 months earlier with the intention of saving the Pakistani economy from collapse. The possibility of these types of large payouts, especially for interference with planned investments that are never actually built, encourages risking serious corruption. So one example of this perhaps theoretical sounding risk is the current contract-based claim against Nigeria, which the government is currently fighting off in the US courts. The award was $10 billion, and this award was brought despite the fact that the US courts have found strong prima facie evidence of fraud on the part of the foreign investor. Now, if you'll excuse me, I believe I skipped a few slides, so I'm going to go back. And if I could have my, excuse me for one moment. Slide 8, please. So the next slide. So how do these types of enormous awards for investments that continue to profitably operate, or for investments that were never even built, actually come about? So there's several reasons, but perhaps the most significant factor is tribunals' increasing willingness to base awards on projections of an investment's expected future income across its entire life cycle. So in this respect, the most common valuation technique is the discounted cash flow, or DCF method. In this regard, tribunal practice departs from previously accepted principles of international law, from the World Bank's own guidelines on the valuation of foreign investments, and from comparable practice of other international courts and tribunals. So just one example is the European Court of Human Rights. This is another international legal regime, which, like the investment treaty regime, does allow for private actors to sue states for monetary compensation. Yet despite these similarities, the difference between compensation awards accorded in these types of disputes before the European Court of Human Rights typically are far lower than those that are made under investment treaties. So for example, in 2004, the UCOS shareholders brought a case against Russia to the European Court of Human Rights, as well as bringing essentially the same legal claims under an investment treaty. At the European Court of Human Rights, they were awarded $2.3 billion in what remains the largest award of compensation ever made by that court. As I mentioned earlier, the UCOS shareholders were awarded a total of $50 billion in compensation under the investment treaty claims. So over to my next slide, please. The use of valuation techniques like DCF aren't only a problem because they depart from the way things are done elsewhere, but the complexity of these types of valuation techniques and the jurisprudence on compensation in general is a problem in and of itself, we would argue. Now, why is that? Primarily because it increases the costs of arbitration and it disadvantages countries that lack the in-house capacity to engage in these detailed arguments about the intricacies of particular valuation methods. DCF is particularly complicated as it relies on a complex, interlocking set of forecasts and assumptions about the future of an investment for its entire lifespan. Foreign investors almost always argue for the use of this method because it usually leads to larger awards. And so these investors rely on specialized financial consultancies to provide evidence in support of their proposed valuations. And host states are then in the position of having to retain their own financial experts in order to rebut the valuation evidence of the investor. And this complexity and the need to engage all of these experts is what drives up litigation costs. So in the case of Tethyan Copper, the claimant in that case spent $4.5 million on financial experts and $17.5 million on legal fees for the compensation phase of the proceedings alone. Pakistan spent almost $10 million defending the quantum phase, including both its financial experts and its legal fees. Over to my next slide, please. So the next problem that we wanted to highlight is the fact that as well as being complex and expensive, existing approaches to determining the amount of compensation to be made under an investment treaty can be highly inconsistent and so result in wildly divergent outcomes in terms of the bill ultimately that states have to foot. So arbitral approaches, we would argue, are inconsistent in three quite technical but very important ways. So firstly, they diverge about when it's considered appropriate to calculate compensation based on expected future income. So when it's appropriate to use methods like DCF. Secondly, tribunals tend to take different approaches to the quality of the evidence needed to back up these projections that underpin the future income-based calculations of compensation. And then thirdly, they diverge in terms of how to account for the risks to an investment's projected income stream across its entire life cycle. So understanding these divergences and these debates can be very technical, but there can be hundreds of millions of dollars at stake in the choice of one approach over the other. And perhaps the best example of this is the different outcomes between Tethyan Copper, the case I've mentioned a few times now, and Bear Creek and Peru. So both cases involved mining projects in the exploration or approval stage. And in both cases, the tribunal found indirect expropriation. But the tribunal in Tethyan Copper used a type of DCF valuation technique to arrive at the award I mentioned earlier of $4 billion plus interest. In Bear Creek, the investor claimed it was entitled to $500 million in compensation based on the DCF method. But the tribunal in that case rejected the use of DCF and instead awarded compensation of $18 million, which reflected the investor's actual expenditure. So on to my next problem, please. So this is the last of the 7 key policy problems that we've identified. And this problem is that, in essence, existing principles on compensation under investment treaties have an all or nothing character. And this is what I mean by that. If a tribunal concludes that a host state's change in the regulatory arrangements governing an investment does not breach an investment treaty, then the investor receives no compensation. If the tribunal concludes that the change does breach the investment treaty, then the investor is typically awarded compensation for all of the loss to the investor caused by the regulatory change under the principle of full reparation. And with some limited exceptions, contextual factors are simply not relevant in the determination of that compensation. So here are just 3 important types of contextual factors that tribunals don't currently take into account. One is the strength of the public interest rationale justifying the interference with the investments. So for instance, at the moment, a German company is currently using an investment treaty to sue the Netherlands for its decision to shut down all coal power plants by 2030 as part of its clean energy transition. If the tribunal rules that the shutdown breached the investment treaty, then the environmental justification for that measure would not be relevant at all to the determination of compensation under the existing jurisprudence. Secondly, and subject again to some limited exceptions, misconduct on the part of the investor is another contextual factor that is currently disregarded by tribunals. So for example, remember the gas case against Egypt that I mentioned earlier, which resulted in a $2 billion award against the state for the breach of a gas supply contract. Now, in that case, the fact that the tribunal found that the foreign investor obtained its gas supply contract through influence over senior government decision makers was not taken into consideration in the calculation of the final award. And finally, tribunals don't currently take into account the host state's ability to pay the award, even where the payment of that amount of compensation in question would be crippling for the host state. So just to briefly recap before I hand over to Jonathan, why are we here today? To talk about potential reforms to the way that compensation is currently awarded under treaty-based investor-state arbitration. Because awards are large and getting larger, including in cases where the investor continues to profitably operate its investments and in cases where the investment in question never even started to operate. These types of awards come about because tribunals have developed a practice which departs from previously accepted principles of international law and the practice of other international courts and also national courts. This practice is inconsistent, complex, and as a result is really expensive for states to navigate. And finally, this practice doesn't take into account critical contextual factors like the public interest, investor misconduct, or states' ability to pay. So for all of these reasons, states may consider that the principles of compensation just aren't functioning the way that they were meant to, and they may decide that it's time for reform. So I'll now pass over to Jonathan, who's going to talk about what that reform could potentially look like. Thank you.
Thanks. Thanks so much, Sarah, for that really clear statement of some of the many and I think quite serious problems with existing approaches to compensation under investment treaties. So I think that really sort of builds a pretty compelling case for a different approach. And the question then is, what should a new approach look like? How can we go about rethinking the principles governing compensation under investment treaties? And as we approached this question, our first step was really to try to articulate a set of basic design principles that clarify what we're trying to achieve, regardless of the specific content of the reform option. And so we can look at these as a kind of minimum set of criteria that we use, or that we might use to inform thinking about more specific proposals. And we came up with 3 of these design principles. So the first one is that a new approach to compensation should be clear and certain. And that clarity and certainty, the ability to be able to state clearly what the principle governing compensation is and what its implications would be for a specific dispute is important for investors, as well as being critically important for host states trying to assess the risks that they face under investment treaties. And a clear and certain approach would also help address some of the more specific concerns with the existing approaches, particularly the complexity and uncertainty and inconsistency associated with the status quo. Our second design principle is that a new approach to compensation under investment treaties should be comprehensive. And what we mean by this is that it's quite extraordinary, actually, but investment treaties actually say nothing about compensation except in relation to cases of expropriation. So the entire body of principles and valuation practices has been constructed by arbitral tribunals insofar as every other breach of investment treaties other than expropriation is concerned. So when we say that a new approach to compensation should be comprehensive, what we mean by that is we shouldn't be just focused on the question of compensation for expropriation, which is the only issue that's actually dealt with in the existing treaties. We need an approach that clarifies compensation across the full range of disputes and breaches that arise under investment treaties. And finally, we thought it was critically important that the approach, a new approach to compensation, is consistent with common approaches across national legal systems. And I don't have time to go into that in too much detail, except to make the very basic point that foreign investors shouldn't be in a position where they're able to achieve a much greater award of compensation under an investment treaty than they would be entitled to in an equivalent dispute in their home state, or that other investors would be entitled to in equivalent disputes under the domestic law of the host state. So at the moment, we have a situation where in many cases, foreign investors will achieve or be capable of achieving a much higher award of compensation under an investment treaty than would be the case in either the legal system of the home state or the host state. So those are our 3 basic design principles that we found it useful to inform our thinking. And if I can have the next slide now, we came up with four different ideas, 4 different proposals for possible options. And these are worked through in more detail in the accompanying paper. But I think one thing that's important to emphasize is that these are options that are intended to start a discussion. So each of these options could be developed or elaborated in particular ways through further consideration based on states' own priorities and perhaps a more detailed practical testing. So the 4 options briefly are an approach to compensation based on balancing a range of competing relevant factors. Alternatively, an approach that is based on capping compensation at a maximum level of the investor's actual expenditure or their sunk cost in making the investment. A third option would be to integrate notions of the host state's gain from interfering with the foreign investment into the calculation of compensation. And a fourth option would be to have compensation governed by the domestic law of the host state. So let's take a look at each of these 4 options in a little bit more detail. The first of these, balancing of relevant factors. So here, for example, instead of the existing approach where compensation is set in principle at the level of the investor's loss resulting from the breach of the treaty, including all lost future income resulting from that breach. You could have an approach where maybe that's one of the factors that's taken into account, the extent of the loss that the investor has suffered. But that factor would have to be considered as part of a balance with several other factors, including the public interest, the history of how the investment was acquired, the extent of the profits that the investor had earned up to the point at which the breach of the treaty took place, perhaps the purpose of the government measure in question, whether the measure was foreseeable, was a risk that the investor should have foreseen at the time it invested. And so these different factors that should be taken into account could be enumerated in treaty language. And in fact, we have some precedent for that in African regional instruments, including in the Southern African Development Community's SADC model bilateral investment treaty. So what are the advantages of this approach? Well, the obvious advantage that's the sort of core of the approach is that it requires tribunals to take a range of other important contextual factors into account in determining compensation, including all those factors that Sarah enumerated that are ignored in existing jurisprudence. Another benefit of this approach, potentially from the perspective of states, is it doesn't require states engaging in treaty reform to be able to come up with a single overarching principle that clearly resolves the question of compensation. It's enough in this approach, or the basis of this approach is just identifying a range of factors that ought to be taken into account. But this is linked to a very serious weakness of this approach as a reform option, in that it would throw the discretion and the judgment in the balancing back to arbitral tribunals. So this approach still leaves a lot of discretion in the hands of tribunals about how these different factors ought to be weighed up and balanced out in coming to a particular award of compensation. And we know through experience with the investment treaty system that that is a real risk, because in areas where tribunals are left with wide discretion, that discretion tends to be exercised in broad ways that favour the interests of foreign investor claimants. So second option, if I can have the next slide then, is simply to cap compensation at a maximum level of the amount that the foreign investor actually invested in making its investment. So at the level of the investor's sunk cost in making the investment. This could actually be developed in a number of different ways. You could combine a cap of this sort with a balancing approach that operates below the maximum cap. So there are ways that this idea could be developed. But in its very simplest form, you could potentially leave existing approaches to compensation largely untouched, just subject to a new overriding maximum, which says that in no circumstances shall compensation exceed the expenditure that the investor actually incurred in making the investment. And done in that way, this is possibly the very simplest reform option, which achieves the biggest change through the simplest amendment to existing treaty language and practice. And as well as that, there is other advantages of this approach. The evidence of the amount that the foreign investor actually invested making the investment is actually relatively quite easy to obtain if you compare it to the sorts of evidence that is required under existing approaches to sustain these complex multi-year projections of the investment's operating expenditure and likely future income stream into the future, which is the basis under existing approaches for the discounted cash flow method of valuation. So the idea of a cap on compensation at the level of the investor's actual expenditure making the investment, that's evidence that's easy to obtain. It's a relatively simple and clear approach. And it also has several precedents in existing awards. In fact, in the very early days of the investment treaty system, this was the dominant approach to compensation. And even now, several tribunals continue to award compensation on this basis. Sarah already mentioned the example of Bear Creek and Peru, in which compensation was calculated on the basis of the investor's expenditure. So those are all real advantages. Obviously, the key advantage is that it dramatically reduces the risk of mega awards, because almost all the mega awards to date have occurred in cases where compensation was calculated according to estimates of the investor's likely future income if the state hadn't interfered with the investment. So that's precluded those mega awards by this method. One criticism that's been made of this approach, because this approach has been out there for some time, even though it's not included in the text of treaties at the moment, it's been out there some time as an option for arbitral tribunals. So there's been some discussion. Some lawyers have criticized this approach on the basis that it might not do enough to discourage governments from expropriating foreign investments. Personally, I think that's a really misguided criticism. In our era at the moment, over the last 20 years, direct expropriation is exceedingly rare, whether in countries where there are foreign investments covered by investment treaties, or in the case of foreign investments that aren't covered by investment treaties. Either way, expropriation, outright expropriation, continues to be very rare. And there's a range of reasons for that, due to other legal and political constraints on states. So I think the criticism of this approach, that it doesn't do enough to sort of tie governments' hands, it doesn't place a big enough penalty on states to discourage them, is actually quite misguided if you look at the evidence. Can I have the next slide, please? A third option really builds on the second option, but extends it by integrating the notion of the host state's gain. So has the host state benefited from admitting the investment and then breaching its investment treaty obligations? So that's really the conceptual core of this third approach. And it's based on an idea, or reflects an idea, that the purpose of investment treaties really shouldn't be to restrain regulatory change. To to the extent that investment treaties have a legitimate purpose, it's a much narrower purpose, and that is simply in discouraging opportunistic conduct by host states. And I mean opportunism in a very precise sense here. So opportunism, an example of that would be if a government auctions off telecommunications spectrum, a foreign investor wins the tender, they pay $2 billion for the right to use 5G spectrum for the next 30 years. And then imagine a couple of months later, the government says, oh, actually, we're cancelling your spectrum. We'll keep the $2 billion though. So that's an example of opportunism. It's a situation where the host state has benefited in a really direct and tangible way from admitting the investment treaty and then breaching its treaty obligations. So if you think that investment treaties should really be targeted just at addressing this sort of conduct and not placing wider constraints on governments changing the regulations governing foreign investment, then it leads you to a slightly different way of thinking about compensation, one which is focused on the host state's gain from having allowed the investment and then breached its treaty obligations. And that's sort of worked through with more specificity as a proposal in our paper. So if I can have the next slide, what are the advantages and disadvantages of that approach? Well, this third approach achieves all the same advantages as the second approach because it actually builds on that idea. So in the third approach, compensation ends up being either the amount that the foreign investor spent, the foreign investor's expenditure in making the investment, or the amount the host state has gained by allowing the investment and then breaching the treaty, whichever of those two amounts is lower. So because the second approach is kind of built into the third approach, it achieves all the same advantages, but has the additional advantage that it deals directly with quite complex factual scenarios rather than just leaving the question of what should happen to compensation in the space below the cap of the investor's expenditure up to the arbitrator's discretion. So this approach dramatically reduces the amount of discretion that is handed over to arbitral tribunals in determining compensation. But it also has some drawbacks, particularly that it requires some more serious rethinking of existing approaches to compensation. And that's likely to meet a lot of resistance from lawyers working in the system. And it's also more complex than the first or the second approach, although still significantly less complex than existing approaches to compensation under investment treaties. So those are some advantages and disadvantages of the third option. And then, yes, thank you, the fourth, you moved onto the fourth slide, thank you. The final reform idea we had is a relatively simple one, and it's applying the domestic law of the host state, so national law, to determine the amount of compensation. So the question of whether the treaty is breached would still be left to whatever the substantive standards are in the treaty, but then the treaty would say, if there is a breach of the treaty, the amount of compensation is then determined by applying the law of the host state. That has several advantages, that approach, in that it avoids states having to articulate a single principle of compensation to govern the variety of different disputes that arise under investment treaties, but it also avoids undue arbitrated discretion, because that that question of compensation is governed by domestic law, not by the judgment of the arbitrator. And you might be surprised to learn that there's actually precedence for this in existing treaty practice. So in the Indian model bilateral investment treaty, for example, the question of the amount of compensation that should be paid for the acquisition of land is governed by the domestic law of the host state. There are potential challenges with this approach too, though. So disadvantages as well as advantages. It relies on the assumption that tribunals will faithfully interpret domestic law so that they won't just pay lip service to the domestic legal system of the host state and then go away and do whatever they might have done anyway. And there's also, from the perspective of the investor, a concern perhaps that the state could circumvent paying any compensation just by changing its own domestic law governing compensation whenever a dispute arises. So that's a potential concern, although that's something I think that can be addressed through treaty drafting, and maybe we could discuss that more in the questions. So those are really our 4 approaches in kind of basic outline, 4 different possible reform options that we hope will give some kind of focus to a wider discussion about reforming the principles of compensation under investment treaties and illustrate that there really are other alternatives to what we have now out there that are available and that are plausible and could be implemented in practice. So if I can have the final slide now, please. To conclude, I think compensation is an immensely important issue. There's a lot of debate about all these questions of treaty shopping, about, finding the right balance between the state's rights to regulate and foreign investors' rights. All these discussions are important, but at the end of the dispute, there is an outcome, and the outcome, if the investor wins, is compensation. So from a practical perspective for states, this is really the key issue that matters. It's what will be the actual outcome in investment treaty disputes. And the issue's been almost completely overlooked in discussions about reform of the investment treaty system. That's for a bunch of reasons. But I think one of the main reasons it's been overlooked is that it's seen as a complex and highly technical area, and particularly for governments in developing states, that complexity of the existing jurisprudence can be really daunting. It sort of seems like an issue that belongs to the arbitrators, belongs to the lawyers and the valuation experts. But the investment treaty system is international law. It's a treaty system. It's a creation of states. And the really key question for states is whether existing approaches to compensation are operating the way that states intended. Is the system now, are the awards that are being generated now in the types of cases that are generating these large awards, is that how states intended the system to operate? And if it's not how states intended the system to operate, then you don't really need to understand every technical detail of the country risk premium and how that fits into a discount rate in a DCF valuation model, and what sort of evidence might be required to sustain arguments about the country risk premium. I mean, those technical questions are fascinating for the lawyers who work in that space. But for states, the key question is this system operating as intended? And if it's not, then reform is a real priority in this space because of the immense consequences. And what I hope we've been able to show today is that reform's not just a really urgent priority, it's also something that's possible, and that there are alternative options out there. Thanks, and I'll throw it back to Susie now.
Thank you very much, Jonathan. Thank you, Sarah, for this excellent and clear presentation and for these concluding remarks. And I think what one important thing is really that the reform is necessary and is doable. But how to get there, this is where we need to brainstorm and start thinking about approaches. So before we open the Q&A session now, I would like just to remind you that we had a webinar in August this year on damages, also with the two speakers. And you may be interested also to go and look on this webinar. And I will ask my colleagues, Joe or Nyaguti, to post the link on this webinar on the chat for those who are interested. So now we will open the Q&A session. And I think we already had a lot of questions and comments on the chat. The chat was really lively while you are doing your presentation, Sarah and Jonathan. So this show that the question is really important and interesting. And then maybe I will ask Joe if you can propose some of the questions that was asked previously. So we can ask Sarah and Jonathan to respond to them. I apologize if we don't have enough time to respond to all the questions, but we will do our best. We have 25 minutes approximately. So let's start with the first question, please, what we got on the chat.
Thank you, Susie, and thank you, Sarah and Jonathan, for the excellent presentation. And we did receive quite some fabulous questions when you were presenting. So for the earlier questions, I've managed to group them into several groups, and I think many of them are related. So I'm going to just to share some of the questions first, and then maybe leave some to the second round of discussion. First of all, many of the issues you discussed, Sarah, and proposals, reform proposals you mentioned, Jonathan, have raised sweet questions on how exactly can these be done, or for example, Samira from Bosnia asked, in what exact form, at what level this can be best addressed? Is that through multilateral level, through ISDS reform and bilateral investment treaties, or something else? And similarly, others have asked questions regarding to the current reform process, whether any of these has been addressed in the treaties or international norms. For example, Debolina Bhatt from UPS Law School, India, mentioned that so the Sarah's problems or contextual issues tend to be ignored by arbitral tribunals. Do you think this is being addressed somewhat in some of the newer bits, say, for example, India's model bit? Fabian from Friends of Earth Europe also asked if any EU's reform approach have taken any of those concerns into account. Joseph from COMESA also asked the similar questions, asking if there are any particular examples from the international reform processes. So, and there are some other questions relating to the details, like, for example, Quinn from Vietnam, Sarah from Tunis also asked particular questions regarding to the details. Maybe we can leave that to the second round of Q&A before Sarah and after Sarah and Jonathan give a first crack on the earlier questions. Thank you.
Thank you very much, Joe, for this excellent summary and organization of the questions. So Sarah, I will give you the floor first to respond to some of the questions we would like to address. Thank you.
Sure, thank you for that, Susie. I will just cherry pick a few of these questions and leave the rest to Jonathan to come in on. So I think the first one that I wanted to address was this points raised about the Indian model bit, and I think that's a really good point to raise. And so just for the benefit, I suppose, of others who perhaps don't have that text to hand, I think what you're asking about here specifically is the provisions in the Indian model that requires the tribunal to take into account factors in mitigation. to reduce damages in accordance with those factors, which are sort of defined in an inclusive way, including the current and past use of the investments, but also unremedied harm or damage to the environment and things like that. So there is that in the Indian model bit. There's something a bit similar in the Dutch model bit. And we did address this in the longer paper, so you might be interested to have a look. But in short, while we think this is a good reform in the sense that it is comprehensive, to go back to the design principles that Jonathan defined, it's comprehensive in that it addresses all types of treaty breach and not just expropriation. So that's a good thing. The concern that we have with this approach is that it turns factors in mitigation or the elements relating to the nature of the investment, the conduct of the investor, these contextual factors become something to be determined at the very end in determining quantum, as opposed to factors which should be considered in the merits phase, which should go to determining the breach. So that's sort of our main concern, and that is elaborated a bit more in the paper. I would also say I think a concern perhaps around this type of approach would also be that you may just see in practice an escalation of claims, because if investors start to realize that tribunals are starting to bring into account mitigating factors at the end as a type of discount, then that might just inflate how much is being claimed to counteract that. And I think a bit tangentially, there's some interesting data around the increase in claims over time, and the fact that the proportion of the award as or the final award as a proportion of the claim is very steady. So I think we might just see claims inflate and then awards inflates in this type of approach.
Thank you very much. Maybe
thanks, Susie.
Give the opportunity to Jonathan also to respond to some of the questions. Then we can go back to you, Sarah, on some of the questions
sure.
to address. And maybe, Jonathan, you may start with all these questions related to what can be the forum and the form of conducting some of this reform, whatever is the option selected, where to conduct this kind of forum, and using which kind of form. So we had several questions around that. Can you? Yeah,
I gathered that this is something that I think that that many people are going to be interested in as a kind of very practical question. So I think this is reform that can be pursued in different ways and in different forums. So let me just start with the sort of I think the prior question, the basic one, which is how would you actually go about implementing some of these changes? So at a national level, I guess it starts off with consideration, development of a national policy position. Maybe that gets reflected in your country's model investment treaty, if you have one. But even if you don't, there's some thought has gone into this in the national process. And then the next step is to reflect that in new investment treaties. So this is language that can then be incorporated in new investment treaties that then provides a point of reference and a precedent for other states. In terms of existing investment treaties, then that's obviously a huge practical consideration, and a practical consideration that states have grappled with in the context of all sorts of other reforms and concerns about investment treaties. And so really that then comes down to either pursuing amendment and renegotiation on a bilateral basis, or ideally, although it's more challenging, seeking to build consensus at a regional level or even at a multilateral level on a reform instrument or language that can go into a a reform instrument that addresses several different issues, maybe not even just damages, which would then have the effect of amending the entire network of treaties for all the countries that become party to the multilateral reform instrument or the regional reform instrument. And that leads me sort of neatly to the question of what forum should this be pursued in, because in fact in UNCITRAL at the moment there is the early stages of a discussion about such a reform instrument, so that there might be some sort of multilateral treaty where states could essentially opt into different elements of reform, potentially including reform of the principles governing compensation, and thereby modify and amend their existing investment treaties. I think there, you know, the UNCITRAL Working Group III process is a challenging one in some ways, because as I think many people here will know, that mandate there is formally focused on procedural issues, although the idea of what counts as a procedural issue is not defined. And if we look at many of the recorded concerns that do define the UNCITRAL mandate, concerns about incorrectness of arbitral awards, about inconsistency of arbitral awards, about the costs of proceedings, about the duration of proceedings. I mean, these are all issues that are directly problems that arise in relation to compensation. So I think there is a case to be made that reform of compensation is within the UNCITRAL mandate, and it has already been identified as a cross-cutting issue. So I think states that see this as a priority, I think states should see reform of compensation as a priority. I think states that do see it as a priority should be pursuing it through the UNCITRAL process and putting it on the record there and trying to see what can be achieved there, but also realizing that it's not enough just to pursue it at the UNCITRAL process, and steps also need to be taken in other forums as well.
Thank you very much, Jonathan. And I assume this forum can be at national, regional, or continental level, as you pointed before.
Exactly. Yeah.
So these were some of the quite, let's say, general questions or comments, but we also have some very specific question and clarification asked by some of the participants, and some of them directed specifically to Sarah or Jonathan. Maybe we can take few time to respond very quickly to some of these questions and request for clarification. May I ask Sarah to start? I think we had a very few questions for you regarding, for example, approach taken at the EU level, and if this is enough to address the problem. I think you addressed that in the paper. Maybe you can shortly address that and pick up some of the few questions to you, and then I will go back to Jonathan. Thank you.
Sure. Yeah, happy to share a few thoughts on the question about the EU's proposal. And then perhaps I think there's a few specific questions for Jonathan on the gain-based reforms or gain-based considerations reform option. So maybe we can pass over there. I suppose when we're talking about the EU's proposal, really, we're talking about the Multilateral Investment Court. And I think that type of institutionalized reform would address some issues, but it would not address many other issues. And I suppose it would address some of the concerns around the consistency of approaches that are taken by arbitrators. But ultimately, as with all of these things, the devil is in the detail, and what actual principles the court would be required to apply is going to be really what will give you the answer to that question, I believe. And I believe that is still an open question. So I would say it wouldn't necessarily, or it certainly wouldn't not necessarily address all of these concerns. It would really depend on what principles the court was being held to. Jonathan, I don't know if you have additional thoughts on that point, or if you wanted to come in on the specific questions about the reform option.
I do have, I mean, I completely agree with you, Sarah. And I think, have a slightly more sort of specific or pointed concern about the EU's multilateral investment court option and the risk of kind of focusing just on the establishment of this court and then leaving all the other issues, substantive issues, compensation to later. Because there's a real risk that, well, if you set up a multilateral investment court, one of the things that is likely to happen is that the decisions of that court will be more authoritative and more difficult to change. So there's a real risk of setting up that court without first addressing some of these concerns about compensation. And if a multilateral investment court were then to double down on current approaches and say, yes, this is the correct approach, full reparation is the principle we need to apply when there is nothing said in these treaties about the amount of compensation that should be awarded for the breach. And we understand full reparation not just to mean the amount the investor spent in making the investment, but we understand that to mean the amount of income the investor would have earned if the investment had been able to operate continuously for its entire life cycle. So if a multilateral investment court sort of endorses those approaches, then they would then become even more difficult to change. So that's one of the reasons why I think it's important to proceed on reform on the question of compensation in parallel with some of these other developments that are taking place.
Thank you very much, Jonathan and Sarah, on this important question. Maybe you want to come up on the how to calculate state gains. I think we had several questions about that related to one of the option reform you are proposing, right?
Yeah, I mean, so I haven't actually got the text of the questions, but I'll answer it in general terms. And then if people are unsatisfied, then maybe it can come back and I'll try and answer it again more specifically. But the basic, how do you calculate state gain? So the basic is a particular type of gain in this option that we have in mind. It's what has the state gained by allowing the investment to take place and then subsequently breaching the investment treaty. So obvious examples of a gain would be if the state lets an investor go ahead and build a mine, and then as soon as the construction's finished, but before the mine begins operating, the state sends in the military and seizes the mine and then starts operating the mine under government ownership. Then the state has gained the mine. So that would be a question of valuing that gain. That's what the state gained by allowing the investment to take place and then breaching the treaty. In the example I mentioned earlier, if a state has sold a concession to a foreign investor and then turns around a week later and cancels the concession but keeps all the money, then the state has gained the amount the investor paid to buy the concession. So those are the sort of simplest examples that illustrate this basic concept of gain as income or money paid to the state, assets that are seized by the state or that are constructed by the investor and repurposed to state ownership, and genuinely new economic contributions made by the foreign investor that wouldn't have been made in the absence of the investment. So those are, that's the core of this concept of gain, but it's gain relative to the situation the state would have been in if the investment had never been made in the first place. So that is the gain that approach is trying to target. Yeah.
Maybe just to clarify here, because the question was more about should you take into account the gain for the whole economy? Because sometimes also it depends on if you are looking on the local community or the various state agencies. So I think the question was more about that. And from what I'm understanding from you is that it's for the whole economy.
Yeah.
Right? Thank you.
For the whole economy. Yeah, sorry, I misunderstood the question. Yeah, but that's the answer. Yeah.
That's fine. That's fine. Thank you for the clarification. I have to say that we only have 5 minutes left. We still have a lot of questions. I think some of them was addressed during your presentation, so I would suggest we don't go back to them. But I would like to give a chance to maybe one or two last question. Joe, if you can help us to see, is there any question that was not addressed at all by Sarah and Jonathan? Or if Sarah and Jonathan want to select one question each to respond very briefly before we close the webinar.
Well, actually, I think there are a series of more fundamental and broader questions I think will be very helpful for Sarah and Jonathan to address if you allow me to raise those questions on behalf of the participants. So we have, so Jonathan just addressed the question posed by Queen from Vietnam on the calculation of the state gain issue. In terms of other broader and fundamental questions, we have questions from Sean Stevenson from CISDL asking, now, if the investment treaty does the investment treaty requires a wholesale rethink of compensation in international law? Or do you think, in your view, this is really just the compensation issue that we discussed here is really just limited to investment law, that this should be a lex special? Similarly, Sarah Nasir from Tunis, I hope I got it right. She also asked the relationship between this, the discussion today with the 2001 IOC article on the responsibility of state in terms of the principle of full reparation. Is this principle, she asks, is this a principle that should be totally abandoned in order to guarantee just compensation? And do you think this should be neglected in order to avoid huge amounts of compensation? And this is the same question that's being asked by Tony Marcel. Similarly, Oliver from University of Cambridge also asked, what's the relationship then between the investment law and human rights law on this? In terms of the treaty reform, do you think the state should reform their investment jurisprudence through arbitral arguments that integrate human rights law? And Howard Mann, ISD's own Howard Mann, also raised a more practical question in the sense that because of those damages seems to be fueling the legal industry, because many of the time that the practical concerns of these damages also relates to the compensations to lawyers, arbitration institutions, valuation experts, because the participation of these stakeholders in the process that inevitably driving the amount of damages. So given this core role of damages in fueling the system, where and how can significant real change happen? Is real change possible on damages without broader ISDS reform that now seems less and less likely in UNCITRAL? So these are some of the questions raised so far. And if I may just add in one more question there. Simon Batford also just asked a question. So why we are not already seeing more efforts by state to implement these kind of reforms at a bilateral level? And I think the related question is, how come that we haven't seen this discussion that came up for the damages issue until now? So after you.
Thank you very much, Joe. And we now have 1 minute left in theory. So I think there is no way for us to try to address all these questions given the time left. I may give, let's say, 30 seconds for each of you speaker to maybe say one thing that they really want to focus on. But what I will suggest at this stage, because to be able to still have the interpretation and take advantage of it. We cannot really expand too much the webinar, is that we may collect the question and maybe, and I hope Sarah and Jonathan will be fine with that, to prepare some short response, then we can share with you by email after the webinar. I think this will be a more practical way to go forward and make sure we are addressing the excellent questions and comments you raised. So yes, and we are on time. We are supposed to stop now, but if technically it's still possible, I want at least to give Sarah and Jonathan a chance to say a last word, if I may say, before we close it. It's a really interesting discussion. Sarah?
Yes, so thank you so much for all of these excellent questions, and I'm sorry that we won't have a chance to satisfactorily address them all. I might just quickly touch on the last two from Howie and from Simon. So I think on the last question about why there hasn't been more reform activity yet coming from states, I think it's a really interesting question and quite a perplexing one, because there are obviously whole areas of investment treaties that have seen a huge amount of change over the last 10 years. And then this is one enormous area which has seen almost, very little real innovation. We do in the paper identify some other innovations and we address them, but really it hasn't changed. And the question is why? And we can speculate. I suspect there's a lot of reasons, but I personally really think it goes back to what Jonathan mentioned at the end of his presentation around the fact that this debate, this discourse has become very intimidating for states to engage in, and for that reason, it has been left to mostly private practitioners to drive. So I suppose a final message would really be for states to take back control of this issue, and to reiterate what Jonathan said, you don't need to know how to run a DCF model or read all 600 pages of the Tethyon Copper Award to be able to have an opinion on this and to come up with ideas for reform. Very quickly on Howie's point, I agree, it's going to be very, very hard for all of these reasons. And I would just say to states in particular that you need to understand this ecosystem of individuals who have vested interests in the status quo, and you need to think about how to counteract those, but it certainly won't be easy at all.
Thank you very much. Jonathan, yes, let me give you also a chance to say very briefly something, because we really had to stop now. Thank you.
Sure, well, I will very quickly. There are a series of questions relating to the question of full reparation and existing principles. Are we just saying these should be abandoned? I think it's really important to just go back a step and to reiterate that someone referred to the ILC articles. So the ILC articles themselves actually are very cautious about the use of the sorts of income-based valuation techniques that we're seeing drive the mega awards in investment treaty arbitration, even though they are committed in principle to full reparation. And if you look across all the other areas of international law, you'll see there's no part of international law that looks anything like what we see in investment treaties in terms of the size of the awards or the aggressive approaches to valuation. So personally, I think whether we're jettisoning customary international law or not, that's just really the wrong question. I certainly would not include the words full reparation in any new treaty language, because that's the language that tribunals currently say that they're applying when they interpret treaties in this particular way and come up with these insanely large figures. So yes, I would not include any reference to those principles. Instead, I would just start from scratch and say, what are the principles we want here? Of course, there's plenty of precedents for that in human rights models with reference to just satisfaction, in the international trade system that doesn't even have monetary remedies. So it's by no means heretical in international law to just say we should decide based on states' policy considerations what the appropriate remedial principles or compensation principles should be.
Thank you very much, Jonathan, for this clarification. And I'm sorry, I really have to stop now. And would like to thank very much the translator for their patience and accepting to stay. And also, we still have a lot of people still on the call, which means that it's a really important topic. Thank you for your patience. This was for us a first step in this process, because we want to keep the conversation going on and engage on reflection on this reform. And we hope we will be able to organize further webinars and discussion around this issue to find the best way to conduct the reform. As I said, we will send you some response by email to a question we are not able, unfortunately, to address given the time constraint. And I would like to thank again very much Jonathan and Sarah for the excellent presentation, Joe for his great help in the moderation. I thank Sophia for her technical moderation, excellent. And of course, very much, thank you very much to the translator for the excellent translation and their patience. So I hope you find this discussion very useful and informative. And do not hesitate to reach us to continue the conversation in various platforms. We are here and available to assist and discuss with you. So thank you very much for your time today. And I wish you an excellent day, depending on where you are. And we hope we will see you soon on another ISD webinar. Thank you very much for your participation, and see you again. Bye-bye.
Thank you.